You hit her with a bottle, and she suffered a heart attack.
I whopped her with it.
She was trying to get in line ahead of you.
Yes, like an entitled Karen.
You can't use a dangerous instrument against another human being. Period. Grow up.
This is Judy Justice. Savannah Bruce is suing fellow driver Diana Belfontaine for lost wages from false police charges.
Court come to order. All rise.
Be seated, please.
Good morning, Judge. We have case 1083, Bruce versus Belfontaine.
Thank you.
You're welcome.
Miss Bruce, you're a driver for Uber.
Was.
How long were you an Uber driver?
2 years almost.
Your complaint states that you're immunocompromised.
Yeah, I have asthma.
Take medication for it?
I have an inhaler.
And that's it?
Yeah.
This incident happened on what date?
July 31st, 2020.
Briefly and succinctly, it is your claim that the defendant filed a false police report against you, which resulted in your losing your job as an Uber driver.
Yes.
And you want to be compensated to the tune of $10,000.
Yeah, at this point, Your Honor, I've lost over $10,000 in wages.
That's possible.
And I've been blacklisted.
Because you have an arrest for assault. Is that what you're saying?
No, it's a pending battery charge that they kicked me off the platform for.
Okay. Is that action still pending?
It's been dismissed, but Uber will not take my phone calls.
Just a second.
Yes.
I just want to make certain that that criminal action has been dismissed. Otherwise, I would not do this case.
Yes, and I have proof.
I'd like to see the document that dismisses the criminal trial.
Yes.
And then we'll get to the facts. Oh, my dear. Okay, I'll get to this in a second. Okay, so this is what happened, and it was on July 31st, 2020. You and the defendant, who did not know each other prior to this confrontation, were both standing in line, according to what I read, to have your cars washed. You were driving for Uber at the time, and according to you, had been for a couple of years, and had been doing that during the height of the global pandemic. And you claim that you felt specifically threatened in this case because you were immunocompromised. I asked what the nature of that illness was, and you say you had asthma, for which you take an inhaler. Okay, it is your claim that there was a dispute over the defendant cutting in front of your car. She says cutting in front of your car, pushing in where two lanes merged to pay to get into the car wash. You'll explain that to me in a little more depth. According to you, the defendant got out of her car in a violent manner, came up to your car. You opened the passenger window.
My passenger side window is already down.
She came up to the car, you say, acting erratically. She was yelling at you, and she was yelling at you during COVID. She was unmasked. You felt threatened. In order to get her away from the car, according to you, you flung at the car window a empty Pringles can. That's what I believe you say in here. It was an empty Pringles can. I may be wrong. You look as if you want to say something.
Well, the report came
Just. I'm looking at what you said to me in here.
Okay.
Yes, I panicked and I grabbed an empty Pringles container and threw it towards the window. That's what you wrote. You remember writing that?
They wrote that out a little bit wrong. I bopped her with it. But yes, Pringle can.
I grabbed an empty Pringles can and threw it towards the window. So what you're saying now, that is not correct. You hit her with the empty Pringles can.
Yes, Your Honor.
Okay. And then she got back into her car and you decided not to go through the car wash at that time and you left.
Yes,
So far, is that correct? You did not go through the car wash and you left.
Yes, and I never got out of my car.
I didn't say you got out of your car. I said you corrected me and said not that you didn't throw this empty Pringles container at her. You bopped her with it, which means you hit her with it, and then did not wait around to see what happened. You left.
I left.
Subsequently, you discovered that she had, in fact, reported this incident to the police. She alleged that she was, in fact, assaulted by you with an instrument, and you were, in fact, arrested, and you hired a lawyer. Were you assigned a public defender?
Yes.
Okay. And the public defender, according to this, had conferences with the district attorney, and the district attorney applied for a dismissal of this case in the interest of justice. You know what that means?
Yes.
Okay. Well, for those people who may be watching this, those millions of people, Lord willing, who are watching this program, interest of justice, so say the court in this case, and the people of the state of California, the Savannah Marie Bruce. After reviewing the evidence in this case, including the victim's statements, defendant's statements, and independent witness statements, the people conclude that the defendant committed a battery upon the victim. That's the way the court starts. When the defendant struck the victim with a metal water bottle, the defendant had other, less violent means to stop any threat that she felt. That's the conclusion of the court. However, the people also conclude that the defendant could have felt threatened by the victim's aggressive approach to the defendant's car. Therefore, the defendant would likely receive, if the case went to trial, a self-defense instruction. Therefore, she has a colorable self-defense, and the people are unlikely to secure a guilty verdict. That's a verdict beyond a reasonable doubt. That's not my standard here. The first thing that I remember learning as a child was sticks and stones will break my bones, but names will never hurt me. You can't pick up an instrument and use it against another human being. Period. End of discussion.
Savannah Bruce claims fellow driver Diana Belfontaine owes for lost wages from false police charges. Diana is countersuing for attorney fees and damages from an assault.
Okay, my standard here is much lower. It's a preponderance of the evidence, which means more likely than not. Not clear and convincing, not beyond a reasonable doubt. Preponderance of the evidence. So your claim is self-defense, because according to you, as a result of this action, it's on your papers and you can't get a job. I wouldn't actually say it's being blacklisted. You were arrested for an assault, which you were not found not guilty of. You were not found guilty of. The court declined to hear the case in the interest of justice, probably because you have no record.
I have a clean record.
You have a clean record. The court said, oh, she looks like a nice girl. She has no prior record. How old are you?
26.
So you're 26 years old. We have other more important things to do. The defendant, on the other hand, has a counterclaim. Defendant says there was this incident. She did get out of her car. She went over to your car because she was trying to get back into the lane. You weren't letting her get back into the lane because she thought her lane was open. It turned out it was closed, so she was trying to get back into her lane, and you were inching up, not allowing her back into the lane. She got out of her car, probably very irritated, came over to your car and probably started to yell at you. Would that be fair?
That's true.
Probably started to yell at you. Because I know that you say in your answer, you went over to her and you tried to explain what you were doing, trying to get back into the lane because the lane that you thought was open wasn't open. It's like going to a toll booth. It's happened. Well, it doesn't happen to me, but it happens to my husband all the time. We're standing in line and all of a sudden there's no line next to you. Oh, that's a whole new line. I guess nobody else sees that. He goes over and that toll booth is closed. And then he has to go begging somebody in the other lane to let him back in the lane. Can I go in here? And I go in here. I say, they're not crazy about you. They're not letting you in. And he gets mad and more aggressive and he pushes the car closer and closer and closer. So somebody finally lets him in. Would that be a fair statement, Sarah? Okay. Just as long as I don't take the whole heat for this.
Oh.
So I know what happened. She got out. She was angry and it wasn't a quiet conversation. In response to her, I assume there are statements. The court concluded that this was a metal water bottle, not an empty Pringles can. And I assume that there are witness statements to that effect, which I will see, that you hit her with a bottle. She says causing a split lip, which clearly is an assault. It also says that as a result of this, she had a pre-existing heart condition and she suffered a heart attack. She also says that after you were arrested and when you filed a civil case against her, after this dismissal, she was forced to get an attorney. You got a lawyer?
I did not get a lawyer.
You filed it yourself?
Yes.
And you were seeking what kind of damages from her?
Loss of wages.
How much?
$10,000.
Did you have any legal advice when you filed that case?
Not much.
What does that mean, not much? By not a smart lawyer, or you didn't talk to the lawyer much, or what does that mean?
Okay, I didn't have legal advice.
Well, I don't think I believe that.
I have a friend who's a lawyer.
Well, that's a lawyer. If the lawyer happens to be a friend, the friend is not a stupid lawyer.
Hopefully not.
Okay, and so, this friend who's a lawyer suggested that once this criminal case was dismissed and you couldn't get a job anymore with Uber, that you could file a civil case against her for false arrest.
Yes.
Would that be right? So good to be around you for so long. Okay, you are seeking damages in the amount of $10,000 for the assault. Okay,
Yes,
now,
Your Honor.
so we're going to start with you, because that's where it starts, right?
Yes.
You're both sitting in your cars, waiting to get to a single queue in order to pay for the car wash?
I had pulled into the car wash long before her, 30 to 45 seconds before her.
That's not long before. 30 to 45 seconds is not long before.
The way that you summarized it, you said that she was there at the same time as me, and I changed my mind. Well, no, I had been sitting there when she arrived on the scene. I had already turned my wheels, waiting for the traffic to advance so I could complete the merge when she pulled up. I did not see her car until she cut me off. There was no one behind me for 30 to 45 seconds. And then out of the corner of my eye, I could see all of a sudden another car on the scene and cut me off. And I looked over to try and make eye contact with this person, but the windows were completely black. I couldn't see the driver at all. And so the traffic advanced again, and I moved up, and so did she. And this happened probably 3 times before I said, "That's it." I got to tell her because I can't see her through her windows or this person. So I got out. She rolled down her window, and immediately we both started shouting at each other. And her car's small; it's low to the ground.
What were you
So I had bent over.
Just a second. What were you saying to her, and what was she saying to you?
Well, we were both shouting.
Expletives.
Yes, I'm not proud of that.
That I can visualize.
Yes.
Okay, and so you leaned over into her car, and you were screaming at each other, which I assume you were. You did see her car trying to get back into the lane. Don't say no.
I saw her trying to cut me off. And
You saw her trying to either cut you off or get back into the lane. Were your windows tinted?
my back windows are tinted.
Yes. And the front passenger seat?
Kind of tinted, but not as tinted as the back.
Correct.
Yes.
The only one that's not tinted is the windshield.
Yes.
Okay, what kind of car were you driving?
Subaru WRX.
And what happened next?
And I bent down and I started to point to the lane closure because I wasn't able to make eye contact. So when I finally got her attention, I turned my head and I started pointing that lane was closed when she bashed me with a hydro flask. Only it was a hydro flask that had probably ice in it and water. It was heavy and it split my lip.
Do you have photographs of your injury?
Yes.
I'd like to see them, please. Thank you.
They required 2
Just a
stitches.
second. Do you have hospital record?
Yes.
I see them, please. I'm going to wait for you, Ms. Bruce, now to tell me your version of the events of the 31st of July.
Okay. I was in line to get my car washed to continue driving through Uber. It was way before you pay, before you merge. I was over here in the left lane. Miss Belafontaine was in the right lane, got a car ahead of me, and she started cutting me off. She crossed 2 white lines to do it, and I'm still unsure why she was trying to cut me off.
Well, she was trying to get in line ahead of you.
Like an entitled Karen kind
Just a
of
second. She was trying to get in line ahead of you.
Yes, before
Okay.
you're supposed to. I would understand if it was time.
Now I understand she was trying to get in line ahead of you.
Yes.
And?
So we were jockeying for position for about 30 seconds. She gets out of her car and walks up to my passenger side window. Had my windows down, so it was nice. I don't like to run my air conditioner waiting in line that long. And she sticks her head in my window. Am I allowed to cuss?
No, I understand you were cursing. She didn't curse. You
Yeah.
don't have-
What doing? I didn't exchange any words with her. I went into fight in flight mode, picked up a Pringle can, which is the nearest thing I had next to me, bopped her with it. It served its purpose. She got her head out of my car. I pulled away. I didn't feel I needed to be there, and I got away.
The level of your arrogance to me in suing her for your lost wages, the level of your arrogance is astronomical.
I have a kid to support.
I don't care whether you have 10 kids to support.
Savannah Bruce has accused fellow driver Diana Belfontaine of cutting her off at a car wash and filing a false police report. Diana is countersuing, claiming she was assaulted during the confrontation with Savannah.
Do you have a police report? Does anyone have a police report?
Yes. Your Honor, I also have pictures of the car wash where it says please form 2 lanes.
I am taking for granted that she either tried to get back into lane or tried to get in front of you. I believe that. I don't believe that entitles you to pick up a dangerous instrument and strike her with it. Neither did the court that dismissed your case. You originally lied to the police. You.
What did I say?
This is the police report of his conversation with you. I asked Savannah if she hit Diana with any type of water bottle. Savannah denied hitting Diana and stated there was not any physical contact. That's not what you just told me.
That's not what I stated to the police. I said I did not hit her with a water bottle.
That's not what it says here. There was also, in this police report, a statement of a person, neither one of you know the witness, John. I assume not. This is just the person who was behind you in the car wash. That person stated in the police report, John observed as both drivers were merging and not backing down. John watched as Diana, that's you, get out of her car and approach the Subaru. That would be you. John observed Diana get hit with some type of canteen-style water bottle. Diana went back to her car and the Subaru made an 8-point turn and turned around to leave the car wash. John wrote down the license plate of the Subaru. If the witness made that statement that neither one of you know and has absolutely no skin in the game, made this report, and if he was able to see her get hit in the mouth with some sort of a water bottle canteen, then her face was not inside your car because you wouldn't have been able to see that. If if her face was inside your car, as you stated it was in your complaint that you filed before me. So, Ms. Bruce, there are a couple of things that I'm going to say to you. First of all, I can actually understand how these things get started, and it's really stupid. But you don't have the right to use a dangerous instrument or something that is not a dangerous instrument, but when utilized by you, became a dangerous instrument, causing injury to somebody. You have no right to do that, because what had happened was bad words, angry words. And the first thing that I remember learning as a child was sticks and stones will break my bones, but names will never hurt me. Which means if she calls you whatever name she wants to call you, you can't pick up an instrument and use it as a dangerous instrument against another human being. Period. End of discussion. Whatever the words are not sufficient for you to injure somebody. There's another legal inference, and that is when you assault someone, you take the victim with all of their history. In this case, you hit a victim with a cardiac history, and she landed not only in the hospital with a split lip that required suturing, but she also had a heart attack. And the level of your arrogance to me in suing her after this case was dismissed, not on the merits, for your lost wages, is the level of your arrogance is astronomical. Astronomical.
I have a kid to support.
I don't care who you support. She's not responsible for that. You are.
I'm not responsible for
you
the
are.
traffic.
You are responsible for assaulting her and causing her a split lip and a heart attack because she had previous heart condition. And this incident that you created by hitting her with that water bottle, not an empty Pringles can, that type of water bottle, so says an independent witness, and causing her injury, you're responsible for that. She's not responsible for you losing your job. You are. You are. And I don't care whether you have 10 kids to support.
May I say something?
Sure.
She was spitting at me basically.
No, that's not. Don't use the word basically like a 26-year-old. Basically is not what she was doing. She was yelling at you. You said she was yelling at you, and spittle was coming out as she was yelling at you. So you feel threatened. Grow up. You have a kid to support. That means you have to grow up. She doesn't know you a thing.
So she was
your
accusing
case. You asked me if you could ask me a question.
Yeah.
I answered your question. I don't have to answer any more of your questions. You were wrong. I don't say she was right in trying to get in front of you. That's not what I'm here to adjudicate. I'm here to adjudicate your response. And your response was to assault her. And you can't do that. And if you lost your job because of it, good. If that's the kind of temper you have, good. And maybe because you have an immune-compromised system, you should find another venue to work other than being an Uber driver with a lot of strangers in your car. Maybe. In any event, your case is dismissed. You have a counterclaim for $10,000. That's granted. Judgment on the counterclaim for $10,000. We're finished.
It was definitely self-defense.
The whole thing from the very beginning is just unbelievable.
I was very frightened when this lady came to my car. I thought she was going to possibly shoot me.
Judge Judy said it perfectly. The level of her arrogance is astronomical.
She should know not to be putting herself in that kind of situation.
I'm not a person to be bullied.
I can't even talk right now.
There's a lesson for her in this, to grow up.
Have you ever been the victim of road rage?
Not to this extent, but I've gotten a few disgruntled looks or yelling from the inside of their car.
It's frightening.
Yeah.
I think that the defendant in this case, although the successful litigant, should have just been smarter. She's older. I just don't understand that if you can avoid that kind of confrontation,
let it go.
it's not urgently important. So you'll get to pay for your car wash 30 seconds later. Instead, you end up with a split lip and a heart attack. So a couple of lessons to take away. You stay in your car. You want to yell at another person in the car for cutting you off? You want to give them an expletive with one of your hands? Let's stay in your car. Don't get out of your car. Nothing is worth getting into a physical altercation with somebody.
No need to let
Tragic.
it escalate to that level.
Have you been cheated? Go to judyjustice.tv.